So the California Constitution in Article 11 deals with local government. There were most recently additions to it in Proposition 2 on the June 2nd, 1970 ballot. Article 11 actually contains 15 different sections. Section 1 of Article 11 provides that the state is divided into counties, which are so-called legal subdivisions of the state, and the legislature is required to prescribe uniform procedures for county formation, consolidation, and boundary changes. Also, formation or consolidation requires approval by a majority of electors voting in each affected county, and a boundary change requires approval by the governing board of each affected county. Also, no county seat is going to be removed unless 2/3 of the qualified electors of the county vote in favor of such a removal. And also, the legislature can provide for county powers: an elected county sheriff, an elected district attorney, an elected assessor, and an elected governing body in each of the 58 counties that exist today. Section 2 requires that the legislature prescribe uniform procedures for city formation and to provide for city powers. Also, Section 2 provides that except with approval by a majority of the voters, a city may not be annexed or consolidated into another city. Section 3 of Article 11 provides that a county or a city may adopt a charter by majority vote of its electors, and the charter is effective when it's filed with the Secretary of State, and a charter can be amended, revised, or repealed by the electorate. A charter is published in the official state statutes. County charters supersede any existing charters and all laws that are inconsistent with that charter. And the provisions of a charter are the law of the state, and they have the force and effect of a legislative enactment. Section 4 specifies that county charters provide for a governing body of 5 or more members elected by district or at large, and that the individuals elected have to reside in that district. Second, the charters can provide for the compensation, terms, and removal of members of the governing body, that an elected sheriff, district attorney, assessor, or other officers can be determined by the charter, including their appointment, compensation, terms, and even their removal. That the performance of functions required by statute are to be done. The powers and duties of governing bodies is set forth and how to fill vacancies on those governing bodies. And the fixing and regulation by governing bodies by ordinance or powers, duties, qualifications, and compensation of individuals who are appointed. And then finally, this section, section 4, again of Article 11, provides that charter counties have all the powers that are provided by the Constitution or by statute for counties. Section 5 provides that any city charter that provides for the city to be governed may make and enforce all ordinances and regulations regarding municipal affairs and other matters that are subject to the general laws of the state. Section 6 provides that a county and all the cities within it can consolidate as a charter city and county as specified by state statute. Section 7 specifies that a county or a city may make and enforce within its geographical limits all local police, sanitary, and other ordinances that are not in conflict with the general laws of the state. Section 7.5 prohibits a city or a county measure proposed by the legislative body of the local jurisdiction to be submitted to the voters for approval if they propose certain specified items that, again, are enumerated in Section 7.5 of Article 11. Section 8 states that the legislature may provide that counties perform municipal functions at the request of cities that are contained within the county jurisdiction. And also, a county may agree with a city that's obviously within its geographic boundaries to assume and discharge certain municipal functions. Section 9 provides that a municipal corporation may establish, purchase, and operate different public works, such as light, water, power, heat, transportation, or means of communication. Section 10 specifies that a local government body may not grant extra compensation to any public officers or employees after service has already been rendered or a contract's been entered into or performed on. Section 11 provides that the legislature may not delegate to a private person or body the power to make, control, appropriate, supervise, or affect county or municipal corporation improvements or property, or to levy taxes or assessment, or to perform any other municipal functions. Section 12 specifies that the legislature may prescribe procedures for presentation, consideration, and enforcement against claims against local jurisdictions and their officers and employees. Section 17 notes that the provisions of Article 11 relating to matters affecting powers between the legislature and local jurisdictions are to be construed as a restatement of all related provisions of the Constitution in effect immediately prior to the effective date of this article. Section 14 states that a local government that's formed after the effective date of this section of Article 11 cannot levy a property tax unless it's been approved by a majority vote of the qualified voters of that local government. And finally, Section 15 specifies that the allocation of revenues that are derived from taxes under the vehicle license fee law cannot exceed 0.65% of the market value of the vehicle.